As constructive dismissal is such a difficult claim to succeed in, the more evidence that an employee can collate, the better. Any emails that you've followed up, so if there's been an act, a breach to your contract, then an employee should be following this up in paper. Keep a diary entry. Anything where you can link the breaches back to paperwork tips the balance in your favour as opposed to the employer's. You need to show that your contract has been breached as opposed to you just resigning, which will be the employer's case. So in order to do that, collate as much evidence as possible. A good way to collate evidence is to raise a grievance, because you can raise all of the evidence of those breaches. If there's been a course of conduct which is accumulating up to the point of resignation, provide that to the employer to show exactly what has happened. The employer will then have the chance to respond to that, and it may be that the breach of contract is resolved in-house. Alternatively, if it isn't able to be resolved through the grievance procedure, if the grievance is mishandled itself, that can lead to further evidence in support of a constructive dismissal complaint at the end. It's certainly possible for an employee to put together a claim of constructive dismissal. However, it's a very, very difficult claim to succeed in. The vast majority of constructive dismissal claims don't succeed because the employee has waited too long to resign after the breach, or that they've relied on the incorrect term within their employment contract that's resulted in the breach, or that they haven't correctly identified the breach of the implied term. So it's always important in a constructive dismissal claim, if you want to get that success at the end, to seek advice early on. And the best way to succeed is to get advice on a grievance, to get advice on the terms, and to get advice on the potential implications of breaches of those terms, which can result in a successful constructive dismissal complaint.